this decision should add emphasis to the fact that we have massive conflicts of interest on the court, and we need to determine for the court, because they're not willing to do it themselves, what constitutes a conflict of interest and rises to a need for recusal for justices on critical issues.
It's Illinois State's Representative Ryan Spain yesterday after the Illinois Supreme Court ruled against Republicans challenging the legislative maps that were drawn by Democrats after the most recent census. It's Illinois in Focus Daily. I'm Greg Bishop, and with you each and every weekday morning, breaking things down that happened at the State House for you the following morning here. So I appreciate you tuning in, and be sure to get the latest at thecentersquare.com, where you can go and find the headlines, including Illinois Supreme Court ruling against map challenge. Does Dems dirty work, GOP says. If you click through, you can actually watch some of the highlights we're about to share with you now. But you have State Representative Dan Ugasti, House Minority Leader Tony McCombie, and State Representative Ryan Spain, all of which who were party to a lawsuit filed against Democrats over the maps that were drawn. And after the 2020 census, you had those new legislative maps drawn behind closed doors before they brought them out, and those maps were given an F grade by various civic organizations that pushed back against the maps for a variety of reasons. But the Illinois Supreme Court, they ruled against Republicans, citing timeliness issues. Let me just read a little bit from the article here, the pull quotes from the majority opinion. They say plaintiffs could have brought this argument years ago. Their claim that waiting multiple election cycles is necessary to reveal the effects of redistricting is unpersuasive. They said plaintiffs' approach would also be prejudicial and create uncertainty for voters and office holders alike now and in the future as to whether any redistrict plan in Illinois is ever final. The majority opinion further stated that the timing is closer to the next decennial census than the last. Republicans said those are ridiculous arguments. They said that the federal judiciary has given guidance saying that if you're going to challenge a map, wait a couple of cycles to show the negative impacts of the gerrymandered map. That's what Republicans did. And then also the issue of, the uncertainty of judicial and legislative boundaries and whatnot. There are states that change legislative boundaries all the time within 10 years. There's nothing that prohibits that from happening. And even in Wisconsin, Republicans yesterday pointed out that the Wisconsin Supreme Court race up there was all about redistricting and Democrats wanting to get that seat so that they could do redistricting to favor Democrats. Interesting to see where we're at on this, as the Illinois Supreme Court essentially ruling against Republicans in their map challenge. Now, the dissent in this case, the dissent from Justice David Overstreet said he would have allowed the case to proceed. He said to do so would essentially uphold the court's duty to address these claims as an original proceeding and would allow for due process, culminating in an opinion that provides further guidance on political fairness requirements that has been enunciated by the court in its prior precedent, and states the court's position on the issue of political gerrymandering in Illinois. So that was the minority opinion on the Illinois Supreme Court. This has all brought up issues of whether or not the Supreme Court has conflicts of interest and how they should recuse themselves if there is a conflict. And yesterday, after the news, the Illinois Supreme Court ruled against Republicans. House Minority Leader Tony McCombie gathered several others in her office at the State House, and we were there.
Well, unfortunately, it's a sad day. Actually, it's a mad day. The Illinois Supreme Court has done the dirty work for the Democrats, and we are not obviously happy about it. I think anything is just going to be done for the Democrats to hold the majority, to cling to power, to continue to disenfranchise voters, and it's just very disappointing. The governor stated that he would support a fair map, but yet he just stands by, even after seeing the evidence of the study that was done. He just continues to stand by his colleagues to let this continue on and not go forward with a fair map.
So the issue of these maps and the debate about having fair maps not drawn by politicians, but maybe by an independent commission, that's been a debate for decades in this state. If you remember, former Governor Bruce Rauner led a petition drive to try to get that addressed, but nothing really came of that. After they gathered like 600,000 signatures, you had special interest attorneys come in, challenge it in the courts, and the Illinois Supreme Court essentially took it off the ballot. And then what happened is one of the judges, as part of that decision, lost retention, and Republicans highlighted that. But State Representative Dan Ugasti, he talks about how absurd the Democrats' ruling was out of the Illinois Supreme Court.
The decision is You want to see a good reason why this decision never should have come down? Read the dissent from Justice Overstreet. He does a fantastic job in laying out the problems with the decision. It starts with the court itself saying, this might not be timely. Why don't you tell us? Justice Overstreet goes through and tells you, timeliness shouldn't have been an issue raised by the court. It should have been raised by a defendant. But the only defendant that was in the case at the time, the State Board of Elections, represented by the Attorney General's office, said, we're not going to take a position on it even after the court raised it. It wasn't until Speaker Welch and President Harmon decided they had to jump into the case and tell you why it wasn't timely, instead of defending the maps based on the law. Based on the law. That's all we asked for. Base it on the law. So they didn't do that. Instead, the court looks at their prior decisions and says, all these were filed right away, and the last one in 2012 we said wasn't timely. But that only dealt with the issue of compactness. In 2019, the U.S. Supreme Court tells us the partisan gerrymandering issues that we raised, that was the main, an equal component of our case, had to be raised after you had 2 election cycles. That's what we waited for.
Ugasti making those points, and also just raising all kinds of problems with the Supreme Court's decision on the fair maps. And then you get into the issue of these justices on the Illinois Supreme Court getting political contributions from leading Democrats. This was a major issue during the gun ban challenge in the Illinois Supreme Court, dealing with the justices that, before they got elected to the Illinois Supreme Court, received $1 million each from Governor J.B. Pritzker ahead of the election. And there you go. You've got questions of conflicts. State Representative Dan Calkins' attorney, Jerry Stocks, motioned to have these 2 justices recuse themselves, Mary O'Brien and Elizabeth Rochford. So they were asked to recuse themselves, and the courts denied it in the gun ban challenge. I don't think there was a motion to recuse these justices from this case, despite, again, the leaders of the General Assembly, Senate President Don Harmon's connected groups, and House Speaker Chris Welch giving hundreds of thousands of dollars to these candidates. State Representative Ryan Spain says it's time to have some ethics and some conflicts of interest rules, enforceable rules.
Yeah, and just the magnitude of money that has been spent on installing these Supreme Court justices is massive. Right. Direct contributions of hundreds of thousands of dollars from the Speaker, millions more from other parties and interests that are controlled and under examination and audit. So something needs to be changed here. And I think the legislature, as a co-equal branch of government, has got to step forward. And we will. We will introduce ethics reform for the Illinois Supreme Court. I believe it should be included at any ethics omnibus activities that happen here. Those have been in short supply lately, even in a post-Madigan environment. But this decision should add emphasis to the fact that we have massive conflicts of interest on the court, and we need to determine for the court, because they're not willing to do it themselves, what constitutes a conflict of interest and rises to a need for recusal for justices on critical issues.
Will they go to the U.S. Supreme Court with this case? Republicans said they're evaluating all the options with their attorneys. But even the Illinois Supreme Court said we're closer to the next decennial census than we are from the previous one. If you look at Illinois' maps, they have been given an F grade by civics organizations for being overly gerrymandered. That's what we've got. All right, it is Illinois in Focus Daily. Like, subscribe, hit that notification bell, and wake up with us here with the Center Square.